Headline, officers involved in tasing man who caught fire and later died won't be criminally charged, New York Attorney General's office says. By the way, the Attorney General of New York is a George Soros type prosecutor. So for what that's worth, not surprising anybody, I suppose. All right. 3 officers with the Catskill Police Department, this would be upstate New York, were involved in the incident that later left Jason Jones dead. December 15th, 2021. The New York Attorney General's office says criminal charges won't be brought against officers after a man covered in hand sanitizer was tased and caught on fire. I would say was set on fire, but that may be a matter of the mens rea. An incident that left him dead weeks later. 3 officers with the Catskill Police Department were involved in the incident that left Jason Jones dead. December 15th, 2021, several weeks after he was tased by one of the officers. So this happened in late October, and he died 6 weeks later. That must have been a tough 6 weeks. The Attorney General's Office of Special Investigation released its report Friday into the events that led to Jones' death. The investigation concluded a prosecutor would not be able to prove beyond a reasonable doubt at trial that the Catskill Police Department officers involved in the incident committed a crime, and therefore criminal charges could not be pursued. Attorney General Letitia James' office said in a news release. If that name sounds familiar, it's because she's one of the prosecutors going very aggressively after President Trump. The report includes recommendations that the state's Office of Public Safety provide additional training on tasers and similar devices and to comprehensively study all flammable substances that such weapons could ignite, list those substances in the training materials, and send updates promptly to all departments that have such weapons in use. Police originally escorted Jones from a bar on October 30th, 2021, after a call about him being disruptive. He ran from officers and entered the Catskill Police Department lobby about a block away. It's curious behavior. He aggressively knocked on the windows, overturned a table, partially disrobed, and eventually squirted what appeared to be hand sanitizer on his head and shirtless body. We'll see that in the video. The Attorney General's office released videos of the incident in January 2022 showing 3 officers confronting Jones in the lobby. In one of the videos, Jones is seen squirting what appears to be hand sanitizer on his head and shirtless body before going off screen. That's when one of the officers is seen pointing a taser at him and deploying the weapon. Jones is engulfed in flames. It's pretty gruesome, folks. And then falls to the floor as all of the officers exit the lobby. The officers ran out of the room to look for a fire extinguisher. According to a statement from the Attorney General's office, nearly 14 seconds later, one of the officers returns to help Jones. A stretcher is brought in approximately 15 minutes later, and Jones is then seen wheeled out of the lobby. All right. So those are the facts as are reported in the media. Now it is time for the video. It's going to play a warning. You're going to hear my voice recorded as part of the warning. This is your last caution, folks. All right, here we go. Warning. The following video contains graphic content that may be disturbing to some viewers. Specifically, a man in police custody will suffer fatal burns. Discretion is advised. This video is presented solely for purposes of legal analysis and education. And that's it. That's the video. A couple things I want to point out is all this spraying the hand sanitizer. Again, I presume that's because he's planning to start a fight with the officers, making himself slippery and hard to control, take everybody to the ground. At least one of these officers appears to have a gun. So this guy right in the middle of the screen looks like he's got a gun on his right hip. So if it goes hands on, now they have to worry about their guns being taken. I'm sure there's lots of complaints that can be made around their tactical decisions here, dealing with this guy without him cuffed, with guns inside the station, guns that would then be accessible to a suspect if there's a fight. But that's not what we're here to talk about today. We're here to talk about the various mental states, mens rea, that particularly the officer with the taser might have had, and how different mental states could lead to different criminal charges or civil liability or no legal liability at all, depending on what he had in mind when he was doing all this. And really, I'll probably largely restrict the discussion up to the point where the flambe begins. There are questions about potential liability afterwards, the fact that the officers ran out of the room, didn't appear to provide aid very promptly. But that's a different matter than the decision to use the taser and what legal liability should apply there. Okay, so now we get academic. Now we get academic. So mens rea has to do with the mental state that someone has, the state of mind they have when they're committing some act, and then there's a bad outcome, and we have to contemplate what the punishment should be, if any, for the act that led to the bad outcome. And that's largely determined by their mental state. And there's various mental states that the law has recognized and defined for legal purposes. One of these is purposefully. And by the way, you'll normally see this word or the word representing some other mental state right in the statutory language. And it becomes an element of the crime that has to be proved beyond a reasonable doubt. So purposefully is when you intend, oh, wait a second. These are all of them. Purposefully, knowingly, recklessly, negligently, innocently. And we're going to step through each of these. So purposefully is when you intend the actual result. An example of this could be a killing for hire. So a wife hires you to kill her husband so she can collect the life insurance. And you only get paid if the husband dies. So his death is the purpose of your shooting of him, for example. You intend the actual result. That would be a purposeful killing. That would be grounds, a mens rea appropriate for a charge of murder. Knowingly is different than purposefully. Knowingly is when you know the actual resulting outcome is almost certain to occur, but that's not your intent. And an example of this might be a carjacking. So you decide you want to take someone's vehicle while they're in it, and to overcome any resistance they may offer, you shoot them while they're sitting in the car, pull their body out, and drive off in the car. You don't actually care whether they die or not. You just wanted them to be unable to resist your taking of the car. So their death is not the actual intent of your shooting on them. But if you shoot someone, you can be almost certain that they're going to die as a result, certainly die or suffer serious bodily injury. So that would be knowingly. That would also be sufficient mens rea for a charge of murder. Now, the difference between the purposefully and the knowingly may result in different degrees of murder, or another way to put that, may result in different punishments for murder. So the murder for hire, where the death is the goal, that could potentially be grounds for a capital murder charge, for example, where you could be executed if you're found guilty of that purposeful crime, whereas knowingly might be 20 years to life in prison, but you're not liable for a capital sentence. Then we also have heat of passion killings. And heat of passion is kind of a odd concept in the sense that you're still acting purposefully or knowingly. So you're intentionally using deadly force on another person in the context of a use of force crime. But you're doing it in hot blood rather than cold deliberation. So the killing for hire, you know, the killer doesn't have any personal feelings about the husband. He's just doing it for the money. The carjacker just wants the car. But some killings, many killings, occur when the killer is in the heat of passion, is in hot blood. The guy who comes home finds his wife in bed with a lover. And what the law says with respect to these heat of passion killings is that because your mind was in that state, you were legally incapable of forming the purposeful or knowing intent required for murder. And it mitigates what would otherwise have been a murder, but for the hot blood. It mitigates what would otherwise have been a murder to manslaughter. And in this case, it would be voluntary manslaughter. We'll talk about involuntary manslaughter in a moment. Voluntary manslaughter is when you desire to harm that person. Okay, you're intentionally directing force at them because you want to cause them harm, but you were in this hot-blooded state. It was not an involuntary act that hurt them. It was a voluntary act. The husband finds his wife in bed with the lover, shoots them both. That was on purpose. That was not an involuntary act. But because of the circumstances, the defense can argue. And typically how this works is the jury would conclude that the elements of murder have all been proven beyond a reasonable doubt. And then the defense can argue that nevertheless, despite that, the murder should be mitigated to manslaughter because of the heat of passion evidence. Okay, the next real mental state is recklessly. So recklessness is when you disregard a known unjustified risk of the actual resulting outcome. But you're not acting purposefully and you're not acting knowingly, or you would have one of those states of mind. So recklessly, a classic example of this would be drunk driving. So you know if you get drunk and you get behind the wheel of a car that you're creating an unjustified risk to the public by driving in an intoxicated state. Now imagine you run somebody over on the way home and kill them. Was that purposeful? Was that knowingly? Purposeful? Did you intend that outcome? Knowingly, was it virtually certain that outcome would result? No, you didn't want to hurt anybody. You just wanted to get home. But you were getting home in a way that created an unjustified risk of death to others, and you deliberately disregarded that risk, and then death results. That's a reckless killing. You were aware of the risk, and you disregarded it. And that is a basis for a charge of involuntary manslaughter. So it's different than voluntary because voluntary involves an intentional use of force against another person. This would be unintentional, but reckless. So instead of voluntary manslaughter, it's involuntary manslaughter. So far, every state of mind we've been looking at is the basis for a criminal charge, criminal liability, knowingly, purposefully, recklessly. As we move down the scale in terms of states of mind, we get to negligently. Negligence is very similar to recklessness in that you're creating a risk of the bad outcome. And then the bad outcome occurs. And your creation of that risk you can't legally justify it. A reasonable person would not have done that. But the difference between negligence and recklessness, why recklessness carries criminal liability, but negligence is only enough for civil liability, is that with recklessness, you were aware of the risk and you disregarded it. In negligence, you were not aware of the risk. You weren't. You should have been. A reasonable and prudent person would have known of the risk. And therefore, we're going to hold you accountable, but not at a criminal level, at a civil level. You'll be held accountable for the harm that you caused. What might be an example of this? I mean, you could argue, for example, that if it snowed on your sloped driveway, and if you live in a winter climate, you know your driveway, it gets slippery. You're not consciously thinking about it, but you just got lazy that morning and you decide not to shovel your driveway, and then a delivery guy comes up your driveway, slips and falls. Well, he would argue that, hey, you should have known. You knew it had snowed. You know your driveway. You know what your driveway is like in the snow. A reasonable person in your circumstances would have known there was a slip and fall risk there that you could easily have mitigated by simply shoveling your driveway. But you didn't do that. You should have done that. And therefore, you're responsible for the harm that resulted from the foreseeable slip and fall. But again, only enough for civil liability, not for criminal liability. You can't go to jail over that. You can get sued and have to pay money. So sometimes we'll see legal arguments that are trying to fit circumstances somewhere between recklessness and negligence, and it's often a bad fit. So sometimes you'll see not the word recklessness used, but you'll see criminal negligence or gross negligence or culpable negligence. And what they're trying to say is it's an aggravated form of negligence. It's not just civil negligence. It's something that should carry criminal liability. To my mind, there's only one step you can take to criminal liability from negligence, and that's really just recklessness. So this should all be recklessness. But I think what sometimes happens is that perhaps the facts can't support proof beyond a reasonable doubt of recklessness. Maybe there's no explicit evidence that the person involved knew of the risk and ignored it, but the outcome is sufficiently bad that the courts feel that mere civil negligence is not enough, that there ought to be some criminal liability. And there's an expression in the law that bad cases make for bad law. So we have a case with a weird fact pattern, and if we just apply the normal legal analysis, we would only get to civil liability. But for some reason, that feels unsatisfying. And when we have those odd facts, suddenly we come up with legal doctrines where the facts can't support recklessness, but we want more than negligence. And so we kind of make up a legal doctrine to achieve that outcome, even though if you really think about the legal doctrine that's created, it's not very substantive. It's not robust. It's not subject to rigorous analysis and consistency. It's basically created just for the facts of that case. So bad facts, bad cases make for bad law, in my opinion. What else did I want to mention here? Another concept. You can have negligence where you're not aware of the risk you're creating, but you should have been aware, right? That's the definition of negligence. But if what you're doing involves an inherently dangerous object, it's automatically bumped to recklessness. Because if it's inherently dangerous, that means it's obviously dangerous. There's no way that that society can accept that you were unaware that you were creating that risk. And this includes things like handling explosives, use of heavy machinery like a crane, handling of guns, handling of dangerous chemicals, dangerous pharmaceuticals. All of these things are so inherently dangerous that we simply will not limit your liability to negligence. So everybody knows that guns are dangerous, and they know which end of the gun the bullet comes out of. So if you're Alec Baldwin and you point what you know to be a real gun at a woman, and you don't first check to make sure it's unloaded, that's not going to be mere negligence. Alec may say, well, I didn't actually know that it could kill Helena Hutchins. Because there's somebody on the staff here on the studio set who's supposed to make sure the gun doesn't have a bullet in it. But guns are inherently dangerous objects. And if you're handling that in such a way that you create an unjustified risk of death to Helena Hutchins by pointing the muzzle right at her and doing what needs to be done to discharge the gun, we're going to treat that as reckless because of the inherently dangerous nature of what you're doing. So you can think of it as automatically bumping what would otherwise have been negligent conduct to reckless conduct. Therefore, from something that would only have carried civil liability to something that carries criminal liability. Then we have innocently. So innocently is a state of mind that carries no criminal liability. And this is when the bad outcome was genuinely unforeseeable by a reasonable actor. And the example I often use is, you go to maybe, here, I'll give a new example. You go to rent a car and you go to the counter and they give you the keys and you go out to the car and you drive out of the parking lot and you get a half a mile down the road. You have to take you have to stop for pedestrians in a crosswalk and the brakes fail. Well, there was no way for you to foresee that the brakes were going to fail in this vehicle that's an unknown vehicle to you. You don't maintain it. You have no responsibility for any of that kind of thing. The rental company is supposed to be providing you with an operable vehicle, not one where the brakes are going to fail. And you run over a bunch of pedestrians in the crosswalk, you kill some people. But your conduct, your state of mind was one of innocence. You didn't kill them purposefully. You didn't kill them knowingly. You didn't kill them recklessly. You didn't even kill them negligently, because you had no duty to ensure the brakes of the vehicle would not fail. Now, maybe if it was your own car, you could argue that you do have a duty of maintenance. And if you didn't do that, if you didn't have your brakes checked regularly or whatever the case might be, you might have failed in a duty to avoid that risk to the public. But in a rental car, I don't see that argument. Now, certainly the rental company's liable, right? It is their duty to maintain the car, to be safe to operate on the public roads before they give it to a customer, but you would not have that responsibility. So if a bad outcome happens, but it was genuinely unforeseeable by whoever technically caused the bad outcome, they were acting with genuine innocence. That would be called a genuine legal accident. And if you were charged with a crime for running over those pedestrians, your argument would be your defense would be a legal defense of accident, that it was genuinely unforeseeable, and therefore you don't even have negligence in terms of liability, much less any kind of criminal liability. Now, I do also want to mention strict liability, because strict liability is kind of an oddity from the normal states of mind. Under strict liability, the government says, we don't care what your state of mind is. We just don't care. If you engage in this particular conduct, you're criminally liable. And it doesn't matter if you had the most innocent state of mind possible. We're still going to hold you criminally liable. And you might think to yourself, well, how can that be appropriate? And a lot of legal scholars would say, we don't really think it is appropriate, that strict liability crimes should not exist. But they do. And the most common one probably is statutory rape. So a guy meets a woman he believes to be of legal age to engage in adult activities. He even checks her driver's license, birth certificate, whatever he may do to ensure that she's of legal age. They have the adult activities. And later it's discovered that in fact, she was not of legal age to engage in adult activities, that she was of a sufficiently young age, despite her appearance, that the conduct now qualifies on the part of the man as statutory rape. And he'll say, but wait a minute, I didn't know she was underage. And he's telling the truth. I didn't know. I didn't do this purposefully. I wasn't looking for someone underage. I didn't do this knowingly. It's not like I was, in a 21 and younger club or something, picking up women. So I knew there was a risk that who I was talking to could be underage. I didn't do it recklessly. I mean, I checked a driver's license, birth certificate, did a background check, whatever. Didn't do it negligently. So it was innocent. I did it innocently. I honestly didn't know. Well, under strict liability, that doesn't matter. Your state of mind doesn't matter. The only thing that matters is that you deliberately engaged in the activity. So, I mean, if you were drugged or unconscious or coerced or duress, those are all legal defenses too. But if you just, went at it with this chick and it turns out she's underage, it doesn't matter what you're meant. You don't need any malicious mental state or negligent mental state in order to be held liable for that. All right. So we get back to this. Okay. We get back to this. So you're the prosecutor. You have these facts before you. What was the state of mind of the officer who deployed the taser? Was it purposeful, the ignition of the suspect here? Was his mental state one where he said, you know what? Say he knew this suspect, and he was aware that a local drug dealer had a hit out on the suspect. 10 grand for anyone who kills this guy so he can't testify against me in court. And the cop's aware of this. And he says, oh my gosh, That's the guy with the bounty on his head. If I kill him, I get 10 grand. Here's my chance. I'm going to set this dude on fire. And he's going to die. His death is my purpose. It's a purposeful killing. Well, then we'd just have a murder, right? An elevated degree of murder, maybe a capital murder. What if that wasn't a state of mind? What if he didn't actually intend this guy to die? But his state of mind was, I am so tired of dealing with these stupid drunks. I'm going to teach this guy a lesson. I'm going to set him on fire. And he can enjoy what that feels like. Now, he doesn't want him to die in this scenario. But is it reasonably foreseeable that if you set someone on fire, it's going to cause them death or serious bodily injury? Sure, it is. So death is not the point. Death is not the purpose. But he knows death could result. So that, again, would be the basis for a charge of murder here. Now, probably a lesser degree of murder. What if the state of mind was not purposeful or knowingly, but perhaps it was, perhaps it was, he intentionally set this guy on fire, but he had some existing animus with this guy. This is the guy who stole this cop's wife. So he's actually in a state of hot blood when he does this. Well, then the elements of murder would be satisfied, but it could be mitigated down to manslaughter. What if this cop's state of mind was, I know that hand sanitizer is flammable and this guy just covered himself in it and it could be ignited by my taser. But I don't care. I mean, I don't want him to catch on fire. I'm aware of the risk. But I don't want him to catch on fire, but he's got a tasing coming. I don't want to wrestle this guy on the ground. I'm just going to tase him and ignore the risk of him bursting into flames. Well, that would be a state of mind of recklessness, right? You're deliberately ignoring a known unjustified risk, and then the bad outcome results. That would be akin to the drunk driver who runs somebody over in the street. And that would be grounds for a charge of involuntary manslaughter, reckless manslaughter. What if this cop actually did not know of the risk, but he should have known? So what if he got trained on his taser 10 years ago, and in that training, there was a page in the manual that said, do not use on a suspect who's coated in a flammable liquid. And he knows that hand sanitizer is flammable. But he didn't keep up with his training. And he kind of forgot that point. So he's not consciously aware that using the taser could set the suspect on fire. But he should have been aware. A reasonable officer who'd maintained his training would have been aware. So he should have been aware of the risk and the bad outcome results. Well, that would be grounds for negligence. Now, remember, when you're engaged in inherently dangerous activity, negligence can automatically be bumped up to recklessness. So a question here would be, well, do these circumstances arise to inherently dangerous conduct? Is it impossible to imagine that a police officer with any training on a taser would not know of this risk? And then it would be much akin to the Alec Baldwin situation. Even if the cop was not actually aware in the moment that he was risking setting this guy on fire, the combination of the taser, the hand sanitizer, and what he should have known automatically bumps this up to recklessness and involuntary manslaughter. If it doesn't do that, then it's simply negligence. And then the cop, and presumably the department, would be responsible in civil court for a wrongful death, would be the cause of action in a civil court claim. What if no reasonable cop could have known that this would be the outcome? What if this had never happened before? No one knew that hand sanitizer could ignite. At least no one in this cop's position with his experience and training could possibly know that. For all he knows, it's really, he believes and has every reason to believe that the hand sanitizer is no more flammable than if this guy had poured a bottle of water over himself. Well, if there's no way to foresee that this would be the outcome, bursting into flames, then you could argue that the conduct was innocent conduct, not foreseeable, and therefore there should be neither criminal nor civil liability here. Now, when we look at the Attorney General of New York and her conclusion not to bring charges against any of these officers, criminal charges we're talking about, she's a prosecutor, that tells us that she believes, or she says she believes, that she cannot prove beyond a reasonable doubt any of the criminal mental states, the mens rea of purposeful, knowingly, or recklessly. That she can't prove any of those mental states beyond a reasonable doubt. And if you can't, then there is no mental state to support a criminal charge. And that would be an appropriate legal analysis by the prosecutor. You might disagree with her on the facts. You know, I would like to know, if I were considering prosecuting this case, what are the trainings of these police officers, right? Because if he had a training last week on the taser and there was a section of that training on how combustible hand sanitizers are, that would suggest to me that you just can't believe that he didn't know he was creating this risk. And I could prove that beyond a reasonable doubt to a jury. And that would be the mens rea of recklessness, of course, involuntary manslaughter. Or any of the other fact hypotheticals we discussed, that this suspect, you know, maybe he had malice towards a suspect, so it would be manslaughter. Maybe he just wanted to set this guy on fire, not have him die, but teach him a lesson. Could be a lesser degree of murder because it's foreseeable that death would result from the fire. Maybe it's the gang hit. He's going to collect 10 grand, but he has to kill this guy to collect the money. So the death is the purpose of the act. And then we would have an elevated degree of murder. Now, this news article doesn't say anything about civil liability. And of course, as we discussed, civil liability is a lesser mental state. So you don't actually have to know that you're creating the risk. You should have known. It's hard to believe a police officer in the 2020s would not know of this risk, but that would be the argument that would have to be made. And you have to prove that by 51% of the evidence in a civil trial. And then the family of the suspect could collect money, damages, probably from the department more than from the officer. Or you could believe it was completely innocent, completely unforeseeable that this would happen, unforeseeable by this cop with his experience and training. I don't know. You'd have to see the facts to determine whether that was, that certainly would be the defense in civil court if they bother to mount a defense and don't just settle.